This is the Buried in Work podcast, where we share tips and interview experts to help you simplify estate planning and end-of-life tasks.
I'm your host, Adam Zuckerman, and today we have the privilege of speaking with Paul Deloughery, an experienced attorney based in Phoenix, Arizona. Paul has over 25 years of experience in estate planning and probate litigation. He's the founder of Sudden Wealth Protection Law. Today, we're going to be focusing on the critical topic of wills in Arizona, exploring the legal requirements, the common pitfalls, and how to ensure that your will is properly executed. Paul, it is an absolute honor to have you with us today.
Well, thanks for having me, Adam. Good to see you.
Yeah, you too. Let's hop right in. So some foundational questions. What are the basic requirements for a will to be considered valid in Arizona?
Great question. So it has to be in writing. There's no such thing as an oral will. And Arizona recognizes, two different kinds, basically. It can either be in the handwriting of the person. That's not the best way. The best way is to have it be typed out and then, signed by the testator. Testator is a fancy legal word for the person who's creating the will or making or signing the will. So testator. It could theoretically be signed by someone else in the testator's presence if for some reason the testator doesn't have motor ability or doesn't have the ability to write. And it must be witnessed by two witnesses, generally speaking. There's an exception to that of something called a holographic will where it's handwritten, but generally it needs to be signed by two witnesses.
All right. And we'll get into a bit of the specific requirements in a few minutes. Now, when you talk about wills, a lot of people are confused about if a will is valid in this state, if a will is valid somewhere else. But each state has its own specific statutes and legal codes. Can you tell us a little bit about what's guiding the validity of wills in Arizona?
Sure. So there's a number of statutes. There's 142501 that says who can make a will, and it basically gives the eligibility criteria, including age. You have to be 18 years or older, and mental capacity requirements. There's 142502 that basically goes through what I just discussed, that the formal requirements for executing a will, including the need for witnesses and the conditions under which a handwritten will can be valid. And that's always interesting. I discourage people from trying to do a handwritten will. I see them, like at any one time in my practice, I see someone who has a handwritten will and dealing with it. And honestly, there's always problems with it, but I digress. There's something called a self-proved will. That's 142504, and that's where you can have a specific kind of affidavit that's attached to the will that's signed by a notary public. And that's basically it. There's another section that says you can incorporate a separate document by reference, but those are the basic statutory guidelines in Arizona.
Do you have to be a resident of Arizona to create a will in Arizona?
Yeah, that's a great question. Anyone who, you could be driving from California to New Mexico and have the bright idea that you want to do a will, stop off at a lawyer's office and sign a will. Yeah, you could do that.
All right. So the next time we take a road trip to Arizona, everybody's stopping off in your office.
Absolutely.
All right.
Yeah, we're right off Highway 51. So.
Who's eligible to create a will in Arizona? You said that you have to be over 18. Are there any other specific requirements, age, mental capacity?
You have to be of sound mind. So basically what that means is, and it's set forth in the statute, but for the most part, it means that you have to have mental capacity to understand the nature and the extent of your property. You have to understand the natural objects of your bounty, which is a specific legal term of art that means objects of your bounty means your natural beneficiaries. If you're a parent and you have children, the natural objects of your bounty are your kids and not your housekeeper, for example. And you have to understand the legal effect of signing the will. And it also has to be voluntary, so not signed under duress or coercion or undue influence.
All right. Can you explain the difference between a handwritten, a holographic will, and a typed will?
Yep. So a holographic will, handwritten will, has the material provisions have to be in the testator's handwriting. And what that means is Well, I mean, the ideal thing, if you were to do it, and again, this is not the best way to write a will, but if you were to write a will, like the material provisions have to be in your writing. You have to say, I, John Smith, hereby write a will, and I give all my property to my beloved son, Jackie Smith, and and then sign it. So that would actually be a valid will. It's not valid to, for example, something I've seen is someone who takes kind of a will off the internet and then inserts in handwriting things like, like the internet form says, I blank, give everything to blank. And, so the material provisions are, in my example, John Smith, give everything to Jackie Smith, and then sign and date it with no witnesses. That would not be valid because the handwritten part just says John Smith, Jackie Smith, and and then it just has a signature. Well, that doesn't even make grammatical sense. So, and again, the holographic will does not require witnesses, but you do have to have the intent. So, we have a situation where someone signed a Christmas card and put language in it that our position is that it shows testamentary intent, and we're trying to establish that it's a will. The other side is saying that it doesn't show intent because it was just a Christmas card. Anyway, so that's one of the issues with that. And then a typed will has to be signed and by the testator, has to be witnessed by two witnesses, and the two witnesses need to observe the testator signing the will, generally speaking, or at least see the testator acknowledging it. Again, if the person is paralyzed, or witness the testator acknowledging that they signed the will. In other words, if the testator, prepared it, signed it, and then called two people out of the neighbors down the street and said, here, I just wrote this, I signed it, this is my will, and then have them witness it, that could actually be valid. Then there's the option for having the self-proving affidavit that we talked about.
Mm-hmm. And does it need to be notarized then?
It does not need to be notarized. However, that's a great thing to do. And by notarized, I don't mean going down to the UPS store and have someone put a stamp and a signature of the notary. There's a specific format. It's an actual affidavit that says that the notary saw this is the ideal situation, saw the testator, the person signing the will, and the two witnesses all sign all in each other's presence, and then the notary knows or was somehow assured that those people were who they said they were, and then signs it, and that's an affidavit. That's what's called a self-proving affidavit.
Mm-hmm. For those witnesses, do they have to be a specific age? Can they be related to the individual who is creating the will?
Great question. So the witnesses have to be at least 18 years old. You can't get your super smart 3-year-old who just learned how to write as a witness to the will. They have to be competent. They have to know what's going on, that you're signing a will and the significance of it. And I'm going to say, generally speaking, they need to be disinterested. Arizona law is a little bit loose on whether someone. Well, it doesn't specifically prohibit someone from being interested, meaning, if you give everything to your oldest daughter generally should not be a witness to the will, because that's going to create a bunch of problems of allegations of undue influence and so on. But it's not technically prohibited.
Okay. What are some of the mistakes? So that could be one mistake, is having somebody be a witness that is a beneficiary as well. But what are some of the common mistakes that people make when they're creating a will in Arizona that could render it invalid or cause problems down the road?
Oh, Adam, we could go on for hours with this, but I do have a list. So one is lack of witnesses. We just dealt with a will that was signed by one witness, and we tried to figure out some way of making that valid, but there's just no way to fix that. And also just generally improper execution. One of the ways that we tried to fix the situation where it was signed by the one witness was there were actually other witnesses, but they didn't other witnesses to the person signing the will, but they didn't sign it within a reasonable time of the will being executed. And there's case law in Arizona. I I can't remember the specific example. I'm kind of making this up, but like there's a case that says, for example, 10 months after the after the signing of the will, having a witness then sign it, that's too long afterwards. Anyway, so yeah, that just do it right then, have it properly executed. Other mistakes, template without proper execution. Just a lot of people have this idea that they just need a will, kind of like, you just need car insurance, without understanding the specifics of what it actually says. Another problem, ambiguity. And we see this all the time with hand done wills or, self-made wills. There's a difference between how people talk, like just in general in conversation, versus how a legal document is. So if they're not super precise, then there's wiggle room and there's room for other family members and heirs to argue about it. Um, Other mistakes, just having life changes, where you wrote a will and then what was it, the Batman movie, Heath Ledger made a mistake that he had I believe it was a will that had everything go to his sister, and then he had a baby daughter, and then he died, and he never updated the will. And what happened, it actually led to a couple of years of litigation, and eventually the daughter ended up getting the majority of his estate. But that was an example of a life change where it just wasn't updated. And let's see, something else, not considering Arizona community property laws. So Arizona, and we see this with people moving from out of state, where they have one understanding of how things work, but then in Arizona, community property is a very sticky kind of concept, and ends up making property kind of the combined property of the community pretty easily, just by different methods. Anyway, so those are some of the ways that people make mistakes with wills.
All right. Now, we talked about not necessarily needing a notary, though it can certainly help avoid problems down the road. Are there any other unique provisions or requirements in Arizona law that differ from other states concerning wills?
So community property, that's a big one. Holographic wills. So I just looked it up this morning because you prompted me. And I guess there's 14 or so states that do not allow Arizona wills. Alabama is one. Minnesota, where I'm from, does not allow holographic wills, but Arizona does. And uh, yeah, it's so Arizona. Like we still have kind of a cowboy mentality where everyone can kind of do what they want, and like this is the state where you can be driving on the road and just drive off in the desert if you want to. So you know, uh, anyway, there's a certain amount of freedom here. So anyway, so that allows, or I guess along with that, we have holographic wills.
All
Um,
right. So somebody's driving along the desert. They pull off. They're not from Arizona. They get lost because they're just free roading in an
yeah.
area that they shouldn't. And unfortunately, one thing leads to another. Fortunately, though, for them, they did have a will from another state. Is that will valid in Arizona?
It is valid in Arizona. Yeah, as long as it was validly executed or validly signed in the other state, then it is valid here. Yes.
Okay. Now, if you have a valid will in Arizona, you have your witnesses, you get it notarized, even though you don't have to, everything's buttoned up, but you change your mind. Can it be modified? Can it be revoked? And what are the legal methods for doing so?
Yes, that's a great question. So you can modify part of the will by something called a codicil, and the proper way to do that is, let's say paragraph 5 of your will says who is supposed to be the personal representative or the executor of your will, and you just, you don't like, you have a falling out with your second child, so now you want your third child to be in charge of everything. So you can have a codicil that says, I hereby revoke paragraph 5 of my will and replace it with the following. And then you state where child number 3 is now going to be in charge. That's one way. Another way is to just do a brand new will. Now, what I should mention is it's easy. It's easy for people to mess up if you're not being careful with this. For example, I said you can do a codicil, but then there can be confusion about, okay, so you have a codicil dated this date and another codicil dated this date, and then maybe someone only finds the second codicil. So really, the best way to do this is to name it name it the first codicil and the second codicil. And then the other thing is if you want to change things with a brand new will, you have to say that you hereby revoke all prior wills and make this as your last will and testament, because otherwise it creates an ambiguity.
Mm-hmm. Mm-hmm. All right. Now, is there anything else that listeners should know when it comes to wills in Arizona?
Well, let's see. Well, and I think this is probably just general advice. It's good to have a will because I do a lot of probate litigation. I also write wills and powers of attorney and trust and everything, but we do a fair amount of probate litigation. And if you don't have a will, then your loved ones are going to be in a position of having to pick and choose, or possibly fight amongst themselves over who's going to be in charge. And also, without a will, the applicable state law. I mean, if you're a resident of Arizona, then Arizona state law is going to apply, and the persons who inherit under that may not be who you want. We have a situation. Actually, I'll go back to the situation where the person did a will that was not valid because it was signed by only one witness, but he felt very strongly that he didn't want any of his kids. He hadn't spoken to his kids for decades, and so he didn't want any of his kids to inherit anything. Well, unfortunately, because he didn't leave a valid will, it's going to go under state law. And so everything's going to either go to the kids, or honestly, if none of them step up within, a certain period of time, like I'm not sure exactly what it is, but probably within like 10 years, the state's just going to take the assets and then get it.
Well, all right. Now, Paul, you founded Sudden Wealth Protection Law. You do a lot more than just helping people organize and create their wills. You mentioned probate law. Can you take a moment to tell us a little bit about Sudden Wealth Protection Law and how people can find you?
Sure. So I know it's a funny name. The reason for the name is because I've seen over and over that the next generation has a tendency of inheriting money and then blowing it, and what I call sudden wealth, when they get a big lump sum inheritance. And so what we try to do is to smooth out that process so that when they do inherit money, they're a little bit more protected from their own bad judgment. Anyway, so that's the theme of it. And you can just go to suddenwealthprotectionlaw.com and find me there, or find us there.
All right. Paul, thank you so much for sharing your expertise with us today. Wills are clearly an important and essential part of estate planning, and you provided our listeners with a lot of valuable information to consider, especially for those of them that are listening from Arizona. Have a great day.
Great. Thanks, Adam.
Thanks for listening to another episode of the Buried in Work podcast. Remember, you can save 10% on our estate preparation package and games with code podcast10 at buriedinwork.com.